Hello, everybody. And a hello to you too, Ava. She was waiting. Hello, Nana Laura. Hello, She's a Maker. Woohoo! It's She's a Maker time. Hello, C-Rex. I'm so happy you're here, sweetie. Hello, Auntie M, my sweet sis. Hello, Shane. Hello, Sir Philip. Hello, Linda Applegate. Hello, Tiana Miller. I hope everyone is having a wonderful night. It's so good to be here. A little later than I thought I was going to start. Honestly, I thought I was going to go early tonight. And I took my shower. And I don't know where time went. I had my alarm set and everything. I got out of the shower. I did the things, got my hair done and looked at the clock and I'm like, it's 11:30. Oh no. So yeah, it's amazing how that happens. Ooh. Are you good now? You should go get a drink. So, but yeah, thankfully I already had all the content exported and everything, so it was just a matter of me getting here. Oh my. Maybe I should not give you as many tonight since you're having that dry cough. What you think? Should I limit how many you get? No. You're just eating them too quick, that's all. Hello there. How you doing, Tiny Kitten Esquire? Sheesh. She's so funny. There's one left. Oh, hello, Brian Boggs. Great to see you, sweetie. Oh my gosh. Oh no. That's awful. Well, if you need representation, you can email the CEO of the paw firm, and I think they can work something out. Hello, Patrick B. So tonight, we've got a little mix of stuff. I edited on both computers. So we've got Judge Slavin and Judge Washington, just one case apiece on the first run. And then on the second one, we're going to go to Conneaut, Ohio. And then we're going to go somewhere after that. And I don't even remember where it was. But I know we at least have those 3 plus one more that's going to be, golly, what was it? I'll figure it out eventually. I'll figure it out tomorrow. That's what it will be. Yeah. You know how when you can't think of something for the longest time and you like hyper focus on it and it never comes to you until you're just lying in bed and you're just about to drift off and vanilla pudding. Hello, Sherry B. You know I'm perfectly okay with that. Just make sure you hit the like button before you drift off. Spider-Man, my love. So good to see you, honey. Oh my gosh. So YouTube analytics does something different now. They actually tell us content creators who posts the most comments on our videos on what would be considered like the replay crew minis, for instance, not on the live stream comments. So we can actually see like our biggest fans kind of thing. And the top 2 commenters that I have, Finna7 came in at number 1, and Spider-Man was number 2. Those are my 2 biggest fans. Thank you. You don't know how much I appreciate that. It sure is. I have started doing, you know how I would post all of the live stream notifications in the Discord because YouTube didn't notify people often? Well, now I've started posting the Replay Crew minis in there as well. So it's gone from April's live streams to the channel's now just named YouTube notifications, because I'm going to post all of the Replay Crew minis in there as well as the live streams, because I'm sure YouTube's not alerting people. Some of the videos that I have posted, really good ones, haven't even broken 100 on how many views they've gotten, and that's surprising. I've had one that hit over 14,000 views, and then I have so many that are like 86 views or 300 views, and they're equally as good, if not better. So yeah, I think it's a matter of YouTube not notifying people for the most part. So now the Discord notifications will go out for those as well. Yes, I can't tell you how much I appreciate it. All right, let's get into it. Oh, what, baby? Did the kitty scare you? Or do you got to go potty? Oh, I guess we're going to have a paw firm potty break right away. I'll be right back.
Your Honor, I spoke with Mr. Sawicki, and he's going to enter a plea of guilty to the charge with an explanation.
All right, so let me first call the case, get everybody's appearance. So case number 241621 SM, People versus Nicholas Sawicki.
Paragraphs on probation.
James Gazicki on behalf of Mr. Sawicki.
And Mr. Sawicki, your name for the record, please.
Your Honor, Nicholas Tanner Sawicki.
All right, so this is the date and time set for a probation violation, actually a 769.4A violation, correct? Yes. And you were on the deferred sentence program, and it was alleged that you violated because you continued to test positive for cannabinoids, even though you were told not to have any use or possession of any alcohol or controlled substances without a prescription, correct?
Yes, Your Honor.
Does he have a prescription?
No, he didn't. No, he does not, Your Honor.
Okay, so you don't have a prescription, correct?
For medical marijuana or prescription for behind the counter drugs?
Cannabinoids, so that would be for marijuana.
No, I was
Okay.
gonna go
All
get
right,
a medical card.
All right, so, I want to make sure that you had the opportunity to speak with your court-appointed attorney, Mr. Kazicki, is that correct?
Yes, Your Honor, that is correct.
And the two of you spoke with regard to your rights, with regard to the violation, is that correct?
Yes, Your Honor.
You understood all of your rights?
Yes, Your Honor, I do.
Do you have any question about any of your rights today?
No, Your Honor, I do not.
You understand that by pleading guilty today that you'd be waiving those rights because you're not going to have a trial or hearing of any kind. You understand that?
Yes, Your Honor, I do understand that.
Did anybody promise you anything?
No,
Threaten
Your Honor,
you
they did not.
or threaten you in any way?
No, Your Honor, they did not.
All right. So as to the charge of being in violation of your deferred sentence, how do you plead? Guilty or not guilty?
Your Honor, I plead guilty.
Did you test positive for cannabinoids because you used some sort of marijuana product?
Prior to this conviction, I did, Your Honor, but I have not been using since this conviction.
All right, so, well, either there is a factual basis for your guilty plea?
Yes, and he doesn't dispute the reading on it. He says because of his metabolism that it keeps showing up in there. But
Well,
His levels are going up and down and back up. That's the reason for the violation.
so your metabolism, listen, the metabolism is kind of like a tank of gas. It'll start using it and keep using the fuel and keep using the fuel until there's no gas. So at some point, your metabolism will metabolize all of the cannabinoids out of your system and it'll just keep getting lower and lower readings. Someone keeps filling up the gas tank on you every time between services, between oil changes here, I guess. So what I'm saying is you need to get tested again and it needs to go down and it needs to keep going down until it gets down to zero because you're not using it. All right?
Yes,
Just
Your
saying,
Honor.
that's all I'm saying. All right, so I'm gonna go ahead and adopt the recommendation and keep you on the deferred sentence. You're gonna do 8 hours of community service. And do that within the next, I'm gonna say the next 30 days, just because, you know what, if you can do like 2 hours at a time, that way it just gives you more options to get it done. So 8 hours within 30 days. All right?
Your Honor, can
So
I
I'm
ask you
gonna
something?
Sure.
Okay, so Ms. Grasso said that I would have to have a medical card through a primary care physician. I have not had a primary care physician since I was going to my pediatrician. I had a lapse in insurance. I do have a medical condition where I'm suffering from chronic head and neck and back pain every
All right,
night.
so listen. You can tell me all of your symptoms. I am not a doctor. I do have a doctorate, but it's not a medical doctorate. So you can get a medical doctor to say that he thinks that you should have a prescription. I'm not a doctor. I'm not going to challenge somebody who's a medical doctor who says, yeah, that's what you need. So if you need to go to a clinic or go to urgent care or go to some sort of free services, or I don't know, find a doctor that will just like see you and takes cash payments, or I don't know. I trust me, I get that the whole insurance thing sometimes stops people from getting whatever medications they need, or at least the correct diagnosis. But if you have a medical marijuana card that says you have a prescription to use cannabinoids for pain relief, well, you know what? Then if that's what the doctor says you need to do, then that's what I'm not going to challenge a doctor because I'm not a doctor. So
Thank you, Your Honor.
all right.
He's been told.
And he did state that he was so, and Ms. Grasso has properly advised you of that. But in the meantime, and in between time, if you don't have the card, you're going to get written up, and the next time it happens, you could be looking at 93 days in jail. I'm just telling you, I'm not messing around. Ms. Grasso's not here to just mess around either. Okay.
Yes, Your Honor, I do not want to do any jail time, but she said it would not be possible if it wasn't the same doctor I haven't been seeing for the past few years. I do not have a primary care physician. I will go get a medical card.
Listen, I don't care who the doctor is. If it's a doctor, he's a doctor. As long as it's a doctor who can get prescriptions, I don't care who you see. I don't care what arrangement you have with them. That's not up to me. That's between you and your physician. Under the HIPAA laws, I don't even need to know that, and you can't even ask about it. So if there's a doctor who thinks that, who's a doctor who gives you a prescription, if anybody thinks that that's not a doctor, there's some sort of fraudulent doctor, prescription thing going on, then they can do an investigation about it. All I'm saying is if you present a prescribed, prescription from a doctor, I don't care who the doctor is, as long as they're a doctor. So.
And I would have to schedule another hearing, Your Honor, correct, when I get that medical marijuana card, correct?
No, you just need to give it to Ms. Grasso, and Ms. Grasso will note it in the file, because my orders are, you are not to use any illicit drugs or narcotics unless you have a prescription. So if benzodiazepine shows up in your tox screen, well, as long as you got a prescription for benzodiazepine, then you're good. If Xanax shows up in your bloodstream, you got a prescription for Xanax. Again, I'm not the doctor. The doctor obviously said you needed it. There you go. So you understand what I'm saying? As long as you got a prescription for whatever it is, that's between you and your doctor.
Thank you, Your Honor. I understand.
All right. So everybody have a good rest of your day.
All right.
And
have a great day, Your Honor.
Make sure you contact Ms. Grasso so she can set it up the next date.
Yeah, I'll set up community service with them.
All right, and she'll also set up community service options with you, okay?
Thank you, Ms. Grasso. Thank you, Your Honor.
All right, well, have a good day.
And quit arguing about it. Once you hear the answer that you want, stop. And I just noticed the flag behind Judge Slavin looks like a guitar. Like it's the shape of it. And that's so funny because I can so see him as the rock kind. Yeah, I've heard them get kind of testy about the clinics that only deal with cannabinoids. They want it to be a physician, end of story. Like they don't like, and there's some judges that are real tough about that too. I have not heard him, but that's kind of funny. That's cute. Right. Hello, David Mueller. Yes, that is it. I just saw that and I'm like, that's so a guitar. All right. And now we're going to see Judge Washington.
Yep. Bye-bye.
State of Michigan versus David Ritchell. Case number 24S00010.
Tiffany Woods for the people.
Assistant Public Defender Davia Lebo, we have Mr. Rizal. Mr. Rizal, can you state your name, sir?
David Ridgell, good morning.
Thank you. Good morning. Mr. Ridgell, I have to arraign you on 2 violations. Violation number 1 alleges that you tested positive for alcohol via ETG test on October 1st, 2024, in violation of the no alcohol condition of your probation. This is a technical violation for which you can get up to 5 days in the Washtenaw County Jail. Violation number 2 is that failed to submit your drug and alcohol test results. You are being allowed to test at the DNA in Woodhaven, and we have no record of any of those results coming to us. You also failed to provide 12-step meeting attendance reports. And for that violation, you can get up to 10 days in the Washtenaw County Jail for a total of 15 days. You are entitled to have a hearing on these matters if it is found, or if you admit to violating. Like I said, you can get up to 5 days on one, 10 days on another, for a total of 15 days. Do you understand that, sir?
Yes, I understand.
All right, Mr. Lebo?
Thank you. And Mr. Rizal will be admitting to the violation regarding the ETG as well as the violation regarding failing to submit the 12-step sheets. And we do have an explanation for both of those, which does include that he has been attending the meetings. With regard to the testing, what Mr. Rizal has told me is that he has been testing and that his information from DNA is that they were forwarding the results. So I asked the court to consider adjourning that portion of the violation so that I can look into exactly what DNA has been doing.
I want to do these all at one time. I don't do bifurcated, because then what we would end up doing is having a hearing on one part and not a hearing on another, and we don't do that. So,
Thank you, Your Honor. I would ask for an adjournment rather than a hearing at this time.
any response from the people?
Judge, I, I guess I'll wait for the adjournment to make my response then.
All right, I'm gonna adjourn the vote to November 25th, 2024 at 10 a.m. I am gonna request that he test within 24 hours at community corrections.
Of course. Mr. Rizzo, will you be doing that?
Yes, I can. Can I just say one thing? If you don't mind, Your Honor.
It's up to your
About,
counsel.
what about Mr. Rizzo?
So as of right now, I'm completely relying on ride share for transportation, and it will be about at least $160 to get to and from Ypsilanti from my current location. Is it possible that I can at least get the money by Wednesday and go Wednesday morning? If not, I'll try my best to come up with something in 24 hours.
Sir, you have two options. You can get them to get those results to us from DNA within 24 hours, or you can go and test within 24 hours. If neither of those things happen, then you're gonna get a bench warrant. I'm not trying to inconvenience you or cause you to have to spend that much money, but we don't have any results from you at all.
Understood.
Okay? Those are your choices.
Thank you, Your Honor. Mr. Rizzo, will you be emailing your 12-step sheets over to probation today?
Yes, it's been done yesterday.
Thank you. We'll see you then.
Thank you.
Thank you.
Now, I don't do ride share or Uber or any of that stuff. I used to drive Uber, but I don't know how much they charge for rides. Does anybody know, is it really $160 to get, like, I would assume, like from one town to another, but that seems like a lot. That is a lot. Like I don't know. I don't know the exact distance that he lives, but that just seems excessive. And that was unfortunately all that I had on that computer file, but there's another. I still haven't thought of who the third one is. Yeah, there's both of them. There's Billy right there and Earl right there, and they've come for their licky treats, their favorite thing in the world. And I am surprised Billy gave up that quickly. He's usually begging for more. Maybe he is. That makes sense. I know when I drove, if it was in Surge, I got a lot more. And I got a lot more people, trying to manipulate the system or trick me into, just take my friend and then come back for me. And then they'd cancel the ride for them. And after, just as I was pulling up, and I would just drive off because they canceled their ride. I know it sounds mean, but I'm not driving them for free. But yeah, we got that a lot. I gotta put the next case on and then I will open it. And then apparently I have to go get Ava because she's barking.
Court is on the record in City of Conneaut versus Brian Surrey, case numbers 24 CRB 335 and 24 CRB 336. Mr. Surrey was arrested on criminal charges filed against him in both of these cases, as well as an outstanding warrant that was issued in 24 TRD 100. Due to internet issues, Mr. Surrey has been brought up from the Conneaut City Jail where he is incarcerated and is appearing at this hearing by in person. Mr. Surrey, criminal charges have been filed against you in both of these cases. I see that you've received copies of both complaints.
Yeah, just received it.
I'm going to read you your rights, so please pay attention to the rights I'm about to read to you. You do have a right to be informed of and to understand the nature and the elements of the charges filed against you. You also have a right to know the potential penalties that could be imposed. Case number 24 CRB 335, you are charged with one count of menacing by stalking. That is a first-degree misdemeanor. If convicted of this offense, you face a maximum 6 months in jail and a maximum fine of $1,000. Do you understand the maximum potential penalties?
Yes, sir.
Now, there's also one other consequence associated with menacing by stalking. If you are convicted in this case of menacing by stalking, and then are charged at any time in the future with menacing by stalking, the future charge could be enhanced in severity, could be more serious because of this menacing by stalking conviction. Do you understand that?
Can I ask a question? What is a menacing by stalking? What is the...
Okay, well, as I'm going to read it to you. Can you read and write?
A little bit, but illiterate. I can't read.
Okay, well, I'll read it for you.
Yes, sir.
It says that on the 27th day of October 2024 in the city of Conneaut, Brian Surrey did knowingly engage in a pattern of conduct causing another person to believe that the offender will cause physical harm to the other person or a family or household member of the other person, or cause mental distress to the other person or a family or household member of the other person, namely Justice Wallace Sprinkle, in violation of section 537.051A1 of the codified ordinances of the city of Conneaut.
It's my kid's mother. I have not seen...
Mr. Surrey, I'm not here to argue this case with you. I'm not here to even listen to your side of the story. It's my job procedurally to advise you of your rights and to ensure that your rights are protected.
Yes, sir.
Did you understand the complaint I just read? Okay.
And did you understand that you cannot have any contact with Justice Lawless Sprinkle?
In the other case, 24 CRB 336, you're charged with resisting arrest. That is a second-degree misdemeanor where it reads that Brian Surrey, on or about the 27th day of October 2024 in the city of Conneaut, did recklessly or by force resist or interfere with the lawful arrest of himself or another, in violation of section 525.09A of the codified ordinances of the city of Conneaut, Ohio. Did you understand that?
Yes, sir.
Okay, we'll start. Yes, menacing by stalking, 6 months in jail, $1,000 fine maximum. The resisting arrest charge, which I've just read to you, is a second-degree misdemeanor. The maximum potential penalties you face is 90 days in jail and a $750 fine. Do you understand the maximum potential penalties on that charge?
Yes, sir.
You have a right to remain silent and not to say anything during this hearing that might incriminate yourself. Any statement you make could be used against you. You also have a right to a trial to the court. Because you are charged with offenses that carry a possible jail sentence, you also have a right to a jury trial, provided that you timely file with the court a written demand for a jury trial. At trial, you have the right to confront and ask questions of any witnesses who would testify against you. You also have a right to use the court process to secure the attendance of any witness who you would want to testify on your behalf. At trial, you have the right to be proven guilty beyond a reasonable doubt and a right not to testify. You also have a right to have an attorney represent you in this proceeding. Because you are charged with offenses that carry a possible jail sentence, you do have a right to court-appointed counsel and to have a lawyer assigned to represent you, only if you cannot afford one. If you do qualify for court-appointed counsel, there is a $25 application fee and a $50 cost reimbursement assessment that apply. You also have a right to a continuance of this initial appearance hearing in order to retain the services of your own attorney or to consult with your own lawyer. If you are convicted of either or both of these charges or any related offense, you have a right to appeal the conviction or sentence. That must be done within 30 days of the conviction, and you would be entitled to a court-appointed attorney in the Court of Appeals if you receive a jail sentence and cannot afford a lawyer. Now, if you plead not guilty today to both of these charges or either of these charges, I will set your case or cases for further proceedings after today, and I will set a bond. A bond is set by the court to ensure your appearance at all future proceedings as well as to protect public safety. And today you have the right to a reasonable bond. If you are not a citizen of the United States, you are hereby advised that conviction of the offense to which you could be pleading guilty or no contest may have the consequences of deportation, exclusion from admission to the United States, or denial of naturalization pursuant to the laws of the United States. Now, Mr. Suri, you have 3 plea options with respect to each of these charges. You can either plead guilty, not guilty, or no contest. If you plead guilty, that is a complete admission by you to the offense charged. If you plead guilty, the court will find you guilty, and then I will impose sentence. The second option is you can plead not guilty. If you plead not guilty, that is a denial by you to the offense charged. And as I said earlier, if you plead not guilty, I will set your case for further proceedings after today, and I will set a bond. The third option is you can plead no contest. If you plead no contest, that is not an admission of your guilt, but it is an admission by you of the truth of the facts alleged in the complaint filed against you. If you enter a plea of no contest, this court will find you guilty, and I will impose sentence without any evidence being presented against you. However, the plea of no contest cannot be used against you in any later civil or criminal proceedings. Mr. Suri, do you have any questions regarding the rights and plea options that I've just explained to you?
No, sir.
Okay. We'll start with the first charge in 24 CRB 335. This is a charge of menacing by stalking, first-degree misdemeanor. How do you plead?
Not guilty.
Okay. And in 24 CRB 336, to the charge of resisting arrest, a second-degree misdemeanor. How do you plead?
Not guilty.
Okay, the court will accept not guilty pleas in both cases. Are you asking the court to consider appointing an attorney to represent you?
Yes, sir, please.
Do you have any source of income?
Yes, sir.
Where do you work?
Yes.
Where do you work?
I work at the Jefferson Gallery Tattoo Studio, and I'm also a broker.
So both of those are part-time?
My tattooing is only appointments only, but the roofing is every weekday.
Is that seasonal though? Do you work throughout the year?
It depends on what we have, because I know when the weather starts going, we have the church down on Creek Road, we just had the roof on that. And
Who do you work for? What's the name?
Joe,
Joe what?
I don't know his last name, but Jesse, Jesse White is the boss that does the roofing and stuff there.
What do you get paid roofing?
$20 an hour.
How many hours a week do you work?
40.
And how many months of a year do you work?
That I just started that a couple months ago.
Do you work throughout? You don't know. Do you work throughout the year?
Yeah, I was supposed to be working throughout the whole year. They had work all the way up. They have more contracts coming in.
So you work in the winter?
Yeah, we're working in the winter, but not doing the roofing. It's going to be doing inside stuff like finishing, remodeling.
Okay, so you do more than just roofing.
Yeah, gotcha. It's more construction than contracting and everything like that.
And you've been doing that for a couple months?
Yeah, I've been doing contracting my whole life, but I just started with these guys not too long ago.
Right now I'm trying to figure out whether you qualify for court-appointed counsel. And it sounds to me like you make too much money to qualify. That's what I'm trying to get at, Mr. Suri.
I just started working there not too long ago, but
where did you work before?
the gallery in Jefferson. And the tattoo, that's really slow these days. I haven't been able to get a whole lot of tattoos.
Is that your business or someone else's?
No, that's someone else's.
How much on average do you make at the gallery?
A week or a month. It all depends. Like I can get nothing in a week.
On average. A week or a month, whatever's easier for you.
300 a month.
And then, where did you work before this job? You have a company you don't even know who you work for.
They're not even a company, it's just a bunch of guys that do the roofing.
How do you get paid?
Through Joe?
But you get paid, you get a paycheck?
No, it's cash.
Okay.
They get the contracts, they just hire them.
Okay.
Let's just admit to something else illegal while we're in front of the judge.
Where did you work before this?
The gallery.
Full time?
Yep. I wasn't making a whole lot of nothing, though. I had to do something.
Okay, here's what I'm going to do. I'm going to preliminarily appoint the public defender's office to represent you. There's a public defender's representative. I'll make sure she gets her form. Representative here in this building today. And I'm going to say subject to the public defender qualification. Financial disclosure form that you're going to have to complete. Okay, now I'm going to address the issue of bond. And by the way, if you do not qualify for court-appointed counsel, you should get an attorney. I'm going to address the issue of bond. On this other case where I issued a warrant for your arrest in 24 TRD 100, you pled guilty to charges of failure to reinstate your license and a muffler violation back on February 20th of 2024. As part of your sentence, I ordered you to perform 25 hours of community work service by May 31st, 2024. We gave you a form, I gave you a hearing date, I have your signed receipt indicating you received notice of that hearing for June 6, 2024. You failed to appear for that hearing, which resulted in the issuance of a warrant in that case. So help me understand, Mr. Surrey, because this goes directly to the issue of whether you're able to appear or whether you would appear for any future hearings. Help me understand.
It's my fault. I did everything I was supposed to, and I got my brother's the pastor down at the community church, and I did all the work there. Come to find out, I had to get a hold of you to see if I was even able to do the work and get the hours there.
Yeah, that's what it says. That's what the paperwork says that we gave you.
Right.
If you want to use another company or another nonprofit, you have to get, that's not already on our list. You have to give us pre-approval.
That's my fault, but I totally.
So where is the paperwork?
It's at my house.
So what did you just think? You just going to
I
avoid
did
it?
the hours and stuff, and I was going to get a hold of you guys. And every time I came up here, it was either, hey, you guys need to pay this, and I'm like, all right, well, I can't pay that right now. So the $120 and stuff. And they were supposed to get a hold of you and ask if I was able to do that. I had to write a letter.
Yeah, Mr. Surrey, whatever excuses you're giving me are just going in one ear out the other, because that's all they are, excuses. Yeah, you're supposed to get a hold of me, which means you're supposed to write a letter, which means you do something to get in touch with me.
Yes, sir.
So why didn't you?
I'm sorry, sir.
Now, why?
What?
Help me understand why.
There's just a lot of things going on in my mind, sir.
Yeah.
And I'm very sorry. It won't happen again.
The law director submitted a written bond recommendation asking that bond be set in the amount of $10,000 personal recognizance in both of these current cases. The allegations are that on October 27, 2024, the defendant caused Justice Sprinkle to believe he would cause her physical harm. Justice is a woman. Cause her physical harm by following her vehicle and driving by her residence numerous times. The defendant resisted arrest when arrested on this charge and warrants, and asking that the defendant be ordered to have no contact with Justice Sprinkle and the property located at the street in Conneaut. Where do you live? How long have you lived there?
3 years.
Are you the tenant, or are you living with someone else? Is there any reason you need to be in contact with Justice Sprinkle?
She's the mother of my child.
Okay.
And I have not been. I've been trying to contact her on the phone.
Do you have a court order? You have court order visitation rights?
I don't have any of this. I don't have anything for her.
When was the last time you've seen your child?
About 4 months ago, 5 months ago. I've been trying to get a hold of her numerous times. messaging her on her phone, no answer, no nothing. Anytime I went to go by her house, just knock on the door, see if my kids are there, she had moved. She was living at the apartments up in, Highland apartment, I think that's what they are, up in Ashtabula, and I went there, there's no answer, no nothing.
So you established as the father?
I am the father.
Okay, are you paying child support?
No, nothing has been submitted or anything like that.
And the child is how old?
3. White surgery.
Help me understand, you were convicted of fleeing and eluding in Pennsylvania, right?
Yes, about 4 years ago.
It's more like 3 years ago. So,
I was on probation for about 4 years through the year, and I did really good. The only thing I ask is a little bit of help with substance abuse, including alcohol. I don't know the right way to go about, I need to talk to a counselor about how to go about any more help or help and alcohol.
it's the last time you received treatment
For alcohol? Never.
for any treatment, any substance abuse treatment.
I've never been on substance abuse.
You have never received treatment?
Well, that was a DUI, I believe, right? The last one?
Yeah, there's some DUI stuff in there too. Is the Lark here?
I believe so.
Okay. Okay, I'm going to follow the prosecutor's bond recommendation. Case number 24 CRB 335, $10,000 personal recognizance. The defendant is ordered not to consume or possess alcohol or drugs. He is subject to random chemical testing by probation and law enforcement. He is to have no contact with the alleged victim, Justice Sprinkle. He is to remain off the premises. Just not off the premises. I don't want you on the street.
I'm not going to.
Yeah, 141 Conneaut. All this case is pending. I am ordering the defendant to undergo an alcohol drug assessment with the Lake Area Recovery Center. There is a representative here today, and she may have time to meet with you in the jail or at some time before you're released to get that process started. In the resisting arrest case, $5,000 personal recognizance, same conditions, not consume or possess alcohol or drugs, subject to random chemical testing, and to undergo an alcohol drug assessment with the Lake Area Recovery Center. Where did you do your community work service at? Which church?
The Conneaut Community Church.
Excuse me?
Conneaut Community Church.
The Conneaut Community Church? What's your brother's name?
Matt Surrey.
Matt Surrey. Where's the Conneaut Community Church?
It's right down the road on Buffalo. Right on the edge of Buffalo. It used to be Free Will Baptist, then they changed the name to Conneaut Community Church.
You mean right along the railroad tracks?
No, right by, you know where McDonald's is? And O'Reilly's?
Oh, you're talking about the church, the old Episcopal church across from, okay. So you did work for them and you have paperwork to show me.
I just didn't, I did the work and I looked at the paperwork again. I'm like, well, I didn't have this place as a allowable thing, so I was gonna write you a letter about that.
Guess what?
I didn't.
You better submit it. I'm going to hold a contempt proceeding on the same date and time as the pretrial conference in these other cases. If you fail to bring in paperwork,
Yes, sir.
which if it is the Conneaut Community Church, I'm a little concerned. I think your brother should be here too.
Yes.
I'm a little concerned that a family member is the one supervising your community work service. But if it is a community work church, I'll allow it. But you better bring in paperwork and maybe even your brother to vouch for you.
Yes, sir.
Otherwise, I'll throw you back in jail. Look, Mr. Surrey, I'm not messing around with you. You're in my jurisdiction now. If you fail to appear for another hearing, if you have any contact with Justice Sprinkle, if you're on Green Street, if you do anything if you don't do anything that I've just ordered you to do with respect to the alcohol drug treatment or staying drug and alcohol free, I'll revoke your bond, and I'll make sure when you're arrested, you sit in jail as long as I can keep you there. Understood?
Yes, sir.
Okay, take him out of here. Get him out. Thank you.
And I believe the judge. It's Judge Ricky. That's who I couldn't remember.
This is in the District Court of Butler County, Kansas, case entitled State of Kansas versus Elizabeth Louise Albright, case number 2024 CR 76. Ms. Albright appears from the jail Zoom location. James Watts appears as defense counsel. Brett Sweeney on behalf of the state. This matter is scheduled for evidentiary preliminary hearing today. Is there any announcement to be made, Mr. Watts?
Your Honor, we will not need an evidentiary hearing. It's my understanding my client would waive her preliminary hearing and enter a plea to count one of the information, possession of methamphetamine. State would dismiss the remaining count.
All right. Ms. Albright, it's the court's understanding that you would be waiving your right to a preliminary hearing in this case. Do you understand that a preliminary hearing is a proceeding to determine if there's probable cause that a felony crime has been committed and that you committed it?
Yes.
You understand that if you waive preliminary hearing, the court will bind you over for trial at this point without any further determination of probable cause?
Yes.
You understand that once you waive your right to a preliminary hearing, you cannot get that right back, though you may proceed to trial later?
Yes.
Have you had an opportunity to consult with your lawyer before making this decision to waive?
Yes.
And do you now freely and voluntarily waive your right to a preliminary hearing in your case?
Yes.
Does the state of Kansas waive its right to a preliminary hearing, Mr. Sweeney?
Yes, Your Honor.
Court finds that both parties have knowingly waived their rights to a preliminary hearing. Defendant is bound over for trial on any felony charge in the information. The court will proceed to formal arraignment at this time. It's the court's understanding the defendant will be entering a guilty plea at this time. I'll ask at the outset, Mr. Watts, does your client desire the charging document to be read to her?
We would waive that formal reading, Your Honor.
Very well. Then I will proceed. Ms. Albright, again, understanding that it's your intention now to enter a guilty plea and accept conviction for one of the charges of the information, a felony charge, there are a number of questions I need to ask you regarding that. If there is any question that you do not understand, I will give you the opportunity to confer privately with your lawyer before I go any further. Just let the court know if you need that time to get some further advice, okay?
Yes, Your Honor.
I will need you to speak up. I want to make sure that all participants can hear your responses to the court's questions.
Yes, Your Honor.
All right. I want to have you state your full legal name for the record.
Elizabeth Louise Albright,
And how old are you right now?
45,
What's the highest level of education that you've attained?
some college.
Okay. Do you believe you're going to have difficulty understanding any of the legal concepts that we're going to be discussing in court today?
No, Your Honor.
Have you ever been adjudged to be mentally ill?
No, Your Honor.
Are you currently under the influence of alcohol or any drug?
No, Your Honor.
Are you currently taking any type of prescription medication?
Yes, Your Honor. I
Is
take
it
a
mental
rest.
health related?
Depression.
All right. Do you believe the medication that you're taking improves your mental condition?
Yes, Your Honor.
Do you believe it impairs you in any way from understanding what's going on?
No.
So right now, do you believe your mind is clear and that you have a full understanding of what's going on in court?
Yes, Your Honor.
Have you received a copy of your original charging document in the case?
I believe so, Your Honor.
Do you understand the nature of the charge of possession of methamphetamine?
Yes, Your Honor.
You understand that when you enter a plea of guilty, you are admitting that act that's been charged by the state?
Yes, Your Honor.
You also understand that when you enter a plea of guilty, you give up any legal defenses that you might have had to that charge?
Yes, Your Honor.
Are you aware that in a trial, the state must present evidence against you in open court, that any witnesses must testify in open court in your presence, that you have the right to cross-examine witnesses with the assistance of your lawyer, Mr. Watts, and that at a trial, you could present evidence on your own behalf and subpoena your own witnesses to court? Do you understand these things?
Yes, Your Honor.
Understand that it's such a trial that you personally would have a privilege against self-incrimination, which means that you could elect to testify at your choice, but no one could force you or compel you to testify against yourself if you didn't want to. You understand that?
Yes, Your Honor.
You understand that when you enter a plea of guilty, you give up these valuable trial rights that the court has described.
Yes, Your Honor.
You also understand that you have a right to a trial by jury, and that before you could be found guilty, that jury would have to be satisfied as to your guilt beyond a reasonable doubt.
Yes, Your Honor.
You understand that when you enter a plea of guilty, you give up your right to a trial by jury and the requirement that you be found guilty beyond a reasonable doubt.
Yes, Your Honor.
You understand that you have a right to appeal a guilty verdict if you have a trial.
Yes, Your Honor.
You further understand that you may appeal your sentence after entering a plea of guilty, but generally you may not appeal your judgment of conviction after you enter such a plea.
Yes, Your Honor.
Now, are you aware of the possible penalties that could be imposed as a result of this guilty plea that you're attempting to make?
Yes, Your Honor.
Okay, well, let's go over those. First of all, do you understand that you could receive up to a $100,000 fine for this offense?
Yes, Your Honor.
And for a level 5 crime such as possession of methamphetamine on the drug offense grid under the Kansas Sentencing Guidelines Act, in the most favorable criminal history category of I, you could receive as little as a 10-month sentence. However, in the worst criminal history category of A, you could receive up to a 42-month sentence. So the sentencing range is 10 to 42 months in prison, depending on your criminal history. We do not know with certainty, as we participate today, exactly what your criminal history is. You, better than anyone else participating, should know what your own criminal record looks like. But that will be researched by the Court Services Department. And based on the outcome of their research, as of the date of your sentencing, that determines where you fall along the level 5 drug line, and then you'll be sentenced accordingly. Do you understand that?
Yes, Your Honor.
All right, Ms. Albright, do you understand that if you have a person felony on your record already at time of sentencing, you will be presumptive prison under Kansas law?
Yes, Your Honor. I have no person felonies.
All right. In addition to any fine that could be imposed, are you aware that you could be assessed and be required to pay court costs, certain fees, including reimbursement of legal fees and expenses, and restitution to victims, if any are owed, as part of your sentencing orders?
Yes, Your Honor.
You also understand that as a direct consequence of this plea, you will be sentenced to an extended period of reporting probation, reporting parole, or post-release supervision as deemed appropriate by the court at time of sentencing.
Yes, Your Honor.
You understand, Ms. Albright, that both probation and post-release supervision periods generally start at 12 months in duration, but can run up to 60 months under some circumstances.
Yes, Your Honor.
Did anyone discuss with you the possibility of this case being a Senate Bill 123 case?
I do not qualify, Your Honor.
Okay. Senate Bill 123 is a state-sponsored drug treatment program that some offenders at this level are qualified for and some don't. I just want to make it clear to you that if you do qualify for Senate Bill 123, you may be required to participate in a long-term substance abuse treatment program.
I have insurance, Your Honor, that covers those costs.
All right.
Plan on doing that anyways, Your Honor.
All right. And the court very well may order it. Do you understand that?
Yes.
You also understand, Ms. Albright, that the Kansas Sentencing Guidelines Act contains special rules. And if any of these special rules apply to you, it could affect your eligibility for probation or otherwise affect your sentence in some way. You understand that?
Okay. Yes, Your Honor.
All right. Have you had an ample opportunity to discuss legal matters like that with your attorney, James Watts, before proceeding here today?
Yes.
You want any more time with him privately now before we go further?
No.
Okay. Are you satisfied with the services and advice given to you by Mr. Watts as your attorney?
Yes, Your Honor.
Now, this guilty plea that you're attempting to make, has it been based upon any threat or promises as to what this court will do in regards to your sentence or any other type of threat or promise?
No, Your Honor.
You understand that if there are any plea discussions between your counsel and the county attorney's office regarding sentencing recommendations, that this court is not bound by any agreements made. The court may and shall consider those agreements as recommendations, but is not bound by them. Do you understand that?
Yes, Your Honor.
So how do you formally plead to the charge in count one of the information, possession of methamphetamine, a level 5 drug felony?
Guilty, Your Honor.
According to the state's charging document, this took place about February 17 of 2024. Is that when it happened?
Yes, Your Honor.
It happened somewhere in Butler County, Kansas. Where was it?
Andover.
Okay. And you were in possession of the controlled substance methamphetamine in Andover at that time?
Yes.
Where was it?
An empty baggie. Well, it was quite empty in a coin purse, and I believe in the console in a larger purse in my vehicle.
Did you know it was in there?
Yes, Your Honor.
Did you know it was methamphetamine?
Yes, Your Honor.
You have the legal right to possess methamphetamine in the state of Kansas?
No, I do not, Your Honor.
Do you now freely, knowingly, and voluntarily enter a plea of guilty and accept conviction for the level 5 drug crime of possession of methamphetamine?
Yes, Your Honor.
Mr. Watts, do you know of any legal reason why the court shouldn't accept your client's plea?
No, Your Honor.
Mr. Sweeney, are you aware of any such legal reason?
No, Your Honor.
Albright, are you aware of a legal reason or any other good reason why the court shouldn't accept your plea of guilty made here today?
No, Your Honor.
Court will accept the guilty plea made by the defendant, finds that that plea is made voluntarily. She has an understanding of the nature of her charge and the consequences of her plea, and a factual basis for the charge does exist. Court finds her guilty, and the judges are therefore convicted of the level 5 drug crime of possession of methamphetamine, as described in count 1. All other counts of the charging document are dismissed pursuant to plea agreement. Court will order a pre-sentence report be completed to determine Ms. Albright's criminal history. The court will set an appropriate date for sentencing. Mr. Watts, I will propose Monday, December 30 at 1:15 p.m.
I can do that, Your Honor.
I'm sorry, Jim, I didn't hear your response.
Yes, sir, I can do that.
Okay. 1:15 p.m. Monday, December 30th for sentencing in the Albright case. So Albright is ordered to fully participate and cooperate with any pre-sentence assessments that might be called for, risk needs assessments, substance abuse assessments, and the like prior to sentencing. Monday, December 30th, 1:15 p.m. All right. Mr. Sweeney, are you aware of anything else that the court needs to address?
Nothing from the state, Your Honor.
Mr. Watts, anything further at this time?
Yes, Your Honor. My client would ask the court to consider bond. She has been in custody now since she came back into custody approximately early September. It looks like, well, I visited her in the early part of September. She has gone out, or I shouldn't say she's gone out. The facility, the 7th Direction, has gone to the jail and evaluated her. I spoke with Cynthia Arnold, the evaluator in this case, approximately 30 minutes ago. There is a treatment program for her available at 7th Direction today. It is a level 2 outpatient. It would require her a minimum of 9 hours of treatment, outpatient treatment, spread over 3 days at a minimum. So 3 days a week for 3 hours a day at a minimum. It would also require her to enter into a controlled living space. I spoke with my client. She's arranged a Oxford house, I believe in Wichita, if I'm not mistaken. Is that correct?
Topeka.
In Topeka, excuse me. An Oxford house in Topeka to step into. There has been an evaluation. I have a copy of that evaluation before me. I'd email it to you, Your Honor, and I spoke with Mr. Sweeney earlier. My email is down, has been since this morning, so I can't email it to you. But I spoke with Ms. Arnold again about 30 minutes ago. There is a treatment been done. There's a treatment program set up. She is ready to begin that treatment program and she has a Oxford house prepared or a halfway house prepared to step in to do that treatment, we would ask the court to modify her bond to let her enter that treatment. As Your Honor noted, as Ms. Albright noted, she's not going to qualify for Senate bill because of a prior conviction that removes her from that. She may well still fall in a presumptive probation category, but she will not qualify for Senate Bill 123. So this treatment will have to be on her own. And as Ms. Albright noted, she has insurance is ready to pay for that. So we would ask the court to modify her bond to permit her to enter that treatment program. My request, Your Honor, would be an OR bond, or at the very least set a cash bond that she's able to make.
Okay, thank you, Mr. Watts. Mr. Sweeney, what is the state's position on this request?
Your Honor, the state doesn't take a position. I'll note that I'm encouraged by the fact that we're past a critical threshold as the state sees it, but obviously we're here because she didn't appear. And so I think the concerns are still there. You know, if we have a sentencing, is she going to show up or not?
Very well. Mr. Sweeney, I appreciate your input. Ms. Albright, the reason why you're in jail right now is because back on June 18 of 2024, you failed to appear for court. Court entered an order of bond forfeiture bench warrant with a no bond hold due to your failure to appear in a felony case. The court, not being totally heartless, listened to an impassioned plea on your behalf and reinstated bond privileges and allowed you to be back into the community pursuant to an order made on August the 7th of 2024, about 2 months later. And then you failed to appear for a court appearance just 5 days down the line from that. So the court wishes to go through that history to remind you that you're in jail not because you failed to appear, it's because you failed to appear twice. You have shown, Ms. Albright, that you are patently unreliable to be trusted to show up for court on this felony case any other time that you're not in jail. It seems like you've got an impeccable appearance record when you're in jail and a horrible record when you're not. Mr. Watts makes a good argument on your behalf, Ms. Albright. While on one hand, the court wishes to see people be in the community to try to avail themselves of community resources in drug possession and drug use cases to try to get themselves better. But I'll also note that you've had a considerable period of detoxification, I would think, since you've been incarcerated for a substantial period. I have no doubt that you need to change your behaviors and would benefit from an outpatient treatment program, but I don't see that as a compelling set of circumstances where I'm willing to give you another chance. Quite frankly, I just can't count on you to show up for court in December if I don't leave you in jail. Because twice, I'm not going to give you an opportunity, Ms. Albright, to not show up for this court for a third time.
Couldn't I do a GPS monitor, Your Honor?
No,
House arrest?
no. Court denies the request for bond reinstatement. Pending sentencing in this case, which I've set for December the 30th. And I believe I set the time at 1:15 p.m. All right. Counsel, again, is there anything else that the court needs to address currently?
No, Your Honor.
All right. I appreciate your advocacy on behalf of your client, Mr. Watts, and the organization that went into that argument. But quite frankly, your client has burned this court twice on appearance, and she just needs to stay in custody until we can get her case completed. The Albright matter is in recess at this time, and this meeting may be ended for all.
Wow. So because of her failure to appear, well, a couple of them, we'll just say that, she has to sit for 2 months till her sentencing. He is not going to give her any chances because he already did. I think I'd cry too if I got told I had to sit for 2 months in jail, but it's her own fault. She, like you said, the only time she ever appears is when she's in custody. She doesn't really get a choice there. He can be. He absolutely can be. But honestly, I think he's fair. I don't think I've ever seen him do something that wasn't deserved. And I obviously, you know, I haven't seen every case. I'm sure he's, you know, gone too hard on people before, and I didn't see it, but everything that I've ever seen seemed justified. Yep. Yeah, it's her party. She can cry if she wants to. I've not seen that side of him either. Yeah, I really like him. I do. Him and his eyebrows of doom, as Mortimer Duke calls them. But that handlebar mustache that he had going on up there today, I've not seen that side of him either. He I kind of wanted to just pluck it right there and just, you know, like one of those old railroad track villains. I don't know what he was going for. Oh, Chinny. Oh, I don't think I have anything ready. Let me look. I know there was a couple more left on the Bellingham docket that I didn't run last night because oh man. By the time I was to the end of where I stopped it, I was wrecked. I was so tired, but I had driven and taken care of Dad, and it was just too much. So let me see what I have. See if I have anything. I don't remember running a couple of these is the problem. I would have to look at what they are because I don't even know what's on them. Oh, where is Bellingham? Here it is. I'm gonna have to skip ahead. Okay, so this was the dude from last night, and then we had the one after it. Right? We saw the lady. Yeah, we did. I used that loosely. Okay.
All right, Mr. Julian Reyes, cause number 4A0826901. Morning, Mr. Reyes. All right, this is on for an arraignment. I did review probable cause. Any comments on PC from defense?
No, Your Honor.
Court does find PC is established for the charge here at this point. So before I actually go through with arraignment, I do see is there an order for competency? Are we going through with that today?
I believe that Mr. Reyes wants to appear pro se.
Okay. All right, Mr.
I believe he has reviewed his rights with Mr. Powers. Has he signed off on those?
The rights form does have a signature, yes.
Okay.
Okay. Mr. Reyes, sir, did you have an opportunity to speak with counsel over there at the jail?
I don't know. I don't know who I'm speaking to.
Okay. This is the Bellingham Municipal Court. I'm Commissioner Nicholas Henry. We are in open court right now, Mr. Reyes. We're being recorded, and we are on the record. So I have the city attorney here. I also have an attorney from North County Public Defense. That's the public defender's office for Bellingham Municipal, and we are here for an arraignment. What I'm asking you, there is an attorney over in the jail courtroom there. He is speaking with people. Did you have an opportunity to speak with that attorney? Okay. Well, I'm already slightly concerned in the same regard.
Somebody else can make a motion here.
Yeah, I think I can as well. Mr. Reyes, I just want to ask you a couple of questions. Did you review your constitutional rights with the attorney over there? Mr. Reyes, are you tracking anything that I'm saying here, sir? Do you understand what I just said? We're in Bellingham Municipal Court right now.
Yes.
Okay. So, I just want to make sure, did you review your constitutional rights with the attorney over there? Okay.
Yes.
One last question. Deputy Lloyd, all I want to, did Mr. Reyes, did he go into the room and speak with counsel?
Yes, he did.
He did? Okay. Mr. Reyes, I'm going to go through a couple of things with you. I have a feeling I know where this is going, but Mr. Reyes, you are charged with one count of indecent exposure. That is a gross misdemeanor, punishable by maximum penalty up to 364 days in jail and a $5,000 fine.
It definitely is a gross misdemeanor. Now, keep in mind, this hearing started with the defense attorney stating he wanted to represent himself.
The charge itself, the statute reads that you would be guilty of indecent exposure if you intentionally made an open or obscene exposure of your person knowing that the conduct would likely cause reasonable affront or alarm. Do you understand what that charge means, Mr. Reyes?
Yes.
All right. I'm going to go ahead and read your rights through with you. I just want to make sure that there's no question about it here on the record. You do have the right to be represented by an attorney. As I said earlier, there is an attorney over there in that courtroom. It sounds like you did speak with him. Oh, Mr. Powers is there. Good morning, Mr. Powers.
Morning, Your Honor.
We also have Mr. Garner over in our courtroom. Mr. Powers, I guess I just want to confirm. I mean, I know that the document has been signed. You did have the chance to review the rights and the charge of Mr. Reyes?
Yes, Your Honor.
Okay. And does Mr. Reyes wish to proceed with counsel this morning?
No, Your Honor. He wishes to proceed pro se.
Okay. Do you have any concerns at all about Mr. Reyes' ability to proceed at this time?
I do, Your Honor.
Okay.
And those concerns are genuine.
Okay. I think that's enough for me based on my observations and based on Mr. Powers.
There's also recent finding of incompetency in Island County case.
There is.
That was dismissed on 4/19/24, Your Honor.
Okay. So let's get the competency order filled out. The court can make the motion, or, I mean, frankly, defense can based on what Mr. Powers just said. So either way, let's get it filled out. I'm going to go ahead and, frankly, Mr. Guilfoyle, you have a lot more practice doing this than I do. If you don't mind filling that out.
Absolutely.
It's probably going to take twice as long if I do it. As far as dates, we probably want to go out about 3 weeks, I think, at this point. I don't know how long it's taking Western to get these done.
3 or 4 weeks, I think, would be appropriate.
Why don't we do three? There's a recent order in play, a recent evaluation that's been done that may
speed it up.
Shorten the process a little bit.
Okay, we'll do 3 weeks then. So that's going to be November 13th. And can you track along to the next date? We don't need to address it today, but Mr. Reyes has, it looks like, an active bench warrant on one of our matters as well for is that a trespass? I'm trying to pull it up. I just got knocked out. Oh, it's a resisting.
Yeah. Is that the 824 case?
Yes.
Okay.
Yeah, it'll go to November 13th. And we can address it then. Thank you for your patience. Oh, sorry, go ahead.
I filled everything out and I've signed off on the form if the court and defense want to review the document.
Thank you very much for doing that. I do appreciate it, counsel. I'm going to take a quick look. It looks fine on my end, if it looks good to defense.
I think the only other thing we would need to do after this, Your Honor, is just address the release conditions.
Okay. Yes, correct. I think the only other thing I'll add is under the other box, I'll just indicate recent finding of incompetency in Island County.
He's got a song in his head.
Okay. All right, Mr. Gardner, if that looks agreeable to defense, I'll get a signature on the order for competency. And then we do need to address conditions. This would be.
Or is the court going to appoint our office?
Yes, sorry, I will do that. I understand at this point. Yes, I'll find him, Mr. Reyes, eligible for counsel, of course. And then would the city like to be heard on conditions here today?
Yes, Your Honor. Mr. Anderson is asking for $1,000 cash support group performance bond with an anti-harassment order. I would just note that that the protected party does work for BPD, so we would just be asking for an exception that the defendant may go to the courthouse but leave immediately shouldn't he post the bail and be out of custody. I do believe Mr. Anderson already added that language, but just in case, I wanted to put that on the record.
Okay, I'll take a look at it. All right, my O court is freezing, but we can at least attempt to proceed here. Did defense wish to be heard on conditions here today, Mr. Gardner?
I missed what the proposed conditions were.
$1,000 cash or performance bond, no contact or anti-harassment order, and that was it, correct?
Yeah, no objection.
All right.
That's all Mr. Anderson is asking for.
City's request is granted. I'll set the bail $1,000 cash or performance bond today. Court does see Mr. Reyes has previous convictions for felony harassment and assault in the 4th degree. I think there is some risk of a violent offense being committed here, and frankly, this charge itself, I think, is certainly a cause for concern as well. So, $1,000 based on that finding. The court will also make a finding that there is some flight risk. There is an active warrant for Mr. Reyes and several other cases with warrant history. So I'm going to go ahead and fill out that pretrial release order. I am finding Mr. Reyes eligible for the public defender. And I'll enter that pretrial anti-harassment order today. All right, Mr. Reyes, as far as the conditions here, appear timely for any scheduled court hearings, have no new criminal law violations. While the case is pending, you will have to abide by the terms of the anti-harassment order the court is entering here today. I'll review that with you in a moment. You are eligible for the public defender. I am getting you an attorney on board. Your next court date is going to be on November 13th at 8:30 in the morning. That is for a review of the evaluation. Court is ordering that you be evaluated by someone from Western State to make sure that you are okay to proceed and that you understand the proceedings at this point. The anti-harassment order protects a party by the name of Christine Paulson. It does prohibit you from doing a number of things. Do not cause, attempt, or threaten to cause bodily injury, including any type of assault, harass, stalk, or keep under surveillance a protected person. You're simply to have no contact with them. That is face-to-face. It's through a third party. It includes electronic and written contact. Texting, phone calls, emails, and social media are all prohibited with this protected party. Do not knowingly enter, remain, or come within 500 feet of the protected person's residence, school, workplace, person, or wherever they may be. This order does specifically state it is not a violation of this order for you to attend hearings at the Whatcom County Courthouse or the Bellingham Municipal Courthouse, both here in downtown Bellingham, and you must leave the area immediately after any court hearings. This is a pretrial order. It will remain in place until the case is resolved unless it's modified or rescinded in the meantime. I'm going to go ahead and sign off on that. I think with the questions of competency, I'm not sure it makes much of a difference as far as his signature, but
I would feel uncomfortable requesting that we sign that on his behalf at this point.
okay. As far as that order, I think that's fine. I'll just indicate that we reviewed it on the record. The record is pretty clear that there's a competency issue here potentially, so. Okay, there we go. I think that covers everything. The last order, I do need to sign off on the evaluation. Thank you, Mr. Gardner, for getting that signed. I'm glad Oak Court started working.
I think that I figured it out. It needed an email address for defense counsel.
Okay, perfect. All right, there we go. I think we are good to go. All right, Mr. Reyes, thank you for your patience this morning, sir. We will see you on November 13th. I think technically, actually, I'll just throw a judge note in there. I will set an out of custody date if the bail is posted. So, 12/10 you said is where we're going? Okay, I'll just set an out of custody review for, well, you know what, technically it's on for arraignment though. Reyes, so what days, I know Mr. Anderson usually does Thursday mornings, is that still going to be his arraignments?
As far as I'm aware.
Okay, we'll do a Thursday then in
11/14?
Yeah, let's just do 11/14. Okay, here we go, signing off on that. All right, thank you. Mr. Gardner, who's next?
I would call Mr. Rister's case.
All right, Jeremy Rister, cause number 3A01027883. Morning, Mr. Rister.
Good morning.
All right, this is on for pretrial, and it looks like there is a change of plea. Okay, Mr. Rister, I do have some questions I need to ask you about this. It looks like it's to one count. Malicious mischief in the third-degree domestic violence. Have you had the chance to review this document with your attorney, sir?
Yes.
All right, do you have any questions about it for me at this time?
No.
I need to double-check one thing. We actually need to make a finding here on this, I think.
We do, Your Honor.
Yeah, sorry about that. I jumped in the gun here. Mr. Rister, I'm going to be just one moment, sir. I apologize. I didn't see that we had the report back. Let me just take a look.
I'm confident.
All right, I'll be just 1 minute. I appreciate you being patient, Mr. Rister.
No problem.
Okay, this guy seems really nice, but I get an off vibe from him that just makes me uncomfy.
Okay. Well, I did have a chance to just take a quick look there at the competency opinion. Would either party like to be heard on the finding here today?
No, Your Honor.
No, Your Honor.
Okay, I'll go ahead then and order. I just need to upload the order finding competency.
It did say that I am confident, right?
Correct.
Yes, it did, Mr. Rister, and that's what I'm about to make that finding. I'm just trying to get the order uploaded here. All right, so I'm just filling it out based on the report of DSHS. Court does find Mr. Rister is competent to proceed at this time, understands the nature of the charges against him, and can assist his attorney in his own defense. So you might need to refresh the page, counsel, but there is now an order finding competency uploaded. If you could just sign off on that, and I will, and then we'll get started with the guilty plea.
City is signed.
Thank you, Mr. Copeland.
I'm signing it right now.
All right, I'll go ahead and just keep going then on the guilty plea. I'll come back and sign that in a moment. All right, Mr. Rister, so I'm going back then to the guilty plea. I do have the statement of defendant on plea of guilty to that one count, malicious mischief, third-degree domestic violence. Just to clarify, you did have the chance to review this with your lawyer?
Yes,
All
Your
right,
Honor.
and did you have any questions about it for me at this time, Mr. Rister?
No, Your Honor.
All right, on the defendant's signature line, I see your initials there, JR. Is that acceptable to you as your signature on the document?
Yes, Your Honor.
All right, and do you understand, sir, that by pleading guilty to this charge, you'd be waiving your constitutional rights, which does include the right to a jury trial and the right to remain silent?
Yes, Your Honor.
Okay, let's look at what the recommendation is. It says 364 days jail, suspending 349, so 15 days. Credit for any time already served towards that. Based on your booking date, I think you're well beyond credit on that, Mr. Rister. The fine, $5,000. Suspending 4,700, that is a $300 fine. Excuse me, in an amount to be determined for any damages that were caused. It looks like there is a request for a post-conviction no contact order. You'd have to abide by the terms of that no contact order. And then additionally,
There is language in it, right?
What was that, sir?
There is language in it, right? So we can communicate about my kid?
I'll have to look at it.
Yes, sir.
And Your Honor, I can tell you that the city did not know that this was going to be resolving, so, and this is Mr. Anderson's case, I'm gonna have to refer back to the previous order that was put into place to see if there's any sort of carve-out language. I don't have anything in my notes that say that that would be the case, but, if that was already the case, I have no objection to that.
All right, I'm actually going to sit tight before we. I'll see if I can find it as well, because if that's a sticking point here, obviously I don't want to proceed.
Would have been from March 29th.
March 29th. Okay, there we go. It says defendant.
Because I plan on receiving.
What's that, sir?
I was planning on receiving my kid upon release because I was having her before then.
So what the order that was entered back in March says, defendant may have contact with the protected party through the Talking Parents application. Using that application, the parties may communicate about a child in common. It says shared guardianship in parentheses only. Defendant may have contact with the protected party to facilitate exchange of child in common through a third party or with a third party present.
And Your Honor, for whatever reason, I can't pull up that order. Was the court mind copying and pasting that into the new order?
Yeah, I think I'll just have to type it because I can't copy and paste out of on base, but yeah, I can't get the order up in O-Court either. It doesn't seem to want to work.
We can get to that point later, Your Honor. I'll see if I can continue to try to pull it up on my end.
Okay. All right, we'll backtrack then. Okay, so hopefully that answers your question then, Mr. Rister.
Yes, sir.
So as far as the no contact order and really the recommendation in full, is that your understanding of it at this point? The recommendation that we just discussed, the 15 days, the probation, the evaluations, all that sort of stuff, and the no contact order, is that your understanding of the agreed recommendation here today?
Yeah, I already served that 15 days, right?
Yes. It looks like you have credit for it, although I do need to ask, is this going to be one realistically we need to set for sentencing on Friday?
We did attempt to, we didn't know this one was resolving. We did try to contact her as we were going through this. It sounds like our victim advocate had to leave a voicemail, so we can either set it to out of custody tomorrow afternoon on the domestic violence.
Because he's well beyond credit.
Mm-hmm.
Okay, I think maybe we'll just set it to tomorrow afternoon then.
Due to the nature of the charge, I think that makes the most sense.
Okay, all right, we'll get to that. We'll cross that bridge when we get there, but I think that's what we'll have to do as far as sentencing. So, all right, so Mr. Rister, that is the recommendation, as your attorney noted and as you noted. It looks like you are beyond credit clearly for the 15 days. So, a couple of other questions. Do you understand, sir, that the court is not required to follow this recommendation and could sentence you anywhere up to the maximum penalty here?
Yes, sir.
Other than this recommendation, has anyone promised you anything or threatened you in any way in order to get you to plead to this?
No, sir.
Are you doing it today on your own free will, Mr. Rister?
Yes, sir.
All right, and do you also understand that if you're not a United States citizen, conviction of this crime could carry negative immigration consequences?
Yes, sir.
right. Mr. Gardner, at this time, are you satisfied Mr. Rister is making the change of plea freely, voluntarily, and intelligently with full knowledge of the consequences?
Yes, Your Honor.
Thank you. Okay, Mr. Rister, on cause number 3A0102783 to the charge of malicious mischief in the third degree domestic violence, how do you wish to plead today, sir?
Guilty.
Thank you. And counsel, you've been previously sworn, so go ahead.
Thank you, Your Honor. Your Honor, I'm just pulling up the report here. Your Honor, I'm reading from Officer Brandlin's report. It's dated January 3rd of 2023. On 01-03, I met with Laurel Rister at her residence. Laurel Rister called 911 to report that her adult son, Jeremy Rister, had kicked and damaged her car. Laurel Rister explained that her son is bipolar and currently in what she believes to be a manic state. She continued by saying that she has guardianship over Jeremy Rister's 11-year-old daughter. She took the daughter to Georgia to visit family over the holidays, which upset Jeremy Rister. Yesterday, her electric vehicle battery died, so she was late getting home. Jeremy Rister used that opportunity to go to Laurel Rister's home and get his daughter off of the school bus, which he is not supposed to do. Jeremy Rister took his daughter to his residence, where she stayed at the night and all day today. She did not attend school as scheduled. When Laurel Rister showed up at Jeremy Rister's apartment today to get her granddaughter, Jeremy Rister was in an agitated state and demanded that she take him to McDonald's. Laurel Rister locked him out of the car and refused. Jeremy Rister got angry with her and kicked the car. In the process, he kicked a hole in the rear bumper of the car. Laurel Rister said that she left immediately with her granddaughter and called 911. I noted and took images of Laurel Rister's car with my department iPhone. I went to Jeremy Rister's residence to attempt to contact him, and there was no answer at Jeremy Rister's door. Laurel Rister told me that Jeremy Rister is only able to communicate via messenger when he has Wi-Fi. I've issued Jeremy Rister a sector citation for malicious mischief, third degree domestic violence.
Thank you very much. Based on that sworn testimony, court accepts your guilty plea at this time, Mr. Rister, finding that it was made knowingly, voluntarily, and intelligently with full knowledge of the consequences. There is a factual basis to support the guilty plea. The court finds all elements of the charge have been satisfied beyond a reasonable doubt. The charge has been pled and proven, and the court has entered a finding of guilt to that charge. So, clearly it sounds like we're not ready for sentencing. Am I correct? The parties are in agreement to set this to tomorrow afternoon out of custody?
That is correct, Your Honor.
Okay, is that fine with defense as well?
Yeah, do we need an order releasing him at this point?
Yeah, I'll enter the order here on the judgment and sentence. Just
So do you understand that, Mr. Rister?
Yes, sir. I got to be in court tomorrow.
You gotta be in court tomorrow, at Bellingham Municipal Court. You're gonna be released from custody today.
Can I get that time?
1:30?
1:30. I'll be there.
Okay.
You'll get a copy of the order as well, Mr. Rister, but 1:30 tomorrow afternoon, you will have to be here at the municipal court. Just to be crystal clear, if you are not here at the municipal court tomorrow afternoon, that means the city will no longer be bound by this sentencing recommendation before the court here today. When you eventually come back at a later time, they could ask for anything they want at that point, so you need to be here tomorrow for that agreement to remain in place.
I got a question.
Yes, sir.
Do I need to leave here and go report to probation?
Today, no.
Or wait till
actually,
tomorrow?
Because I'm not ordering you on probation.
Okay.
We haven't actually gone through the sentencing yet. So
You'll probably need to do that after
It'll
court
be tomorrow?
yeah, that'll be tomorrow more than likely, sir. So
Okay,
I'll
no
be
problem.
just 1 minute. I'm almost done with the order here.
And Your Honor, I'm not able to pull up the old order in O court, so I'm gonna have to.
That order's still in effect until we get to J&S, right?
Typically, we enter it at.
Yeah, I know it's a little bit odd, but usually this court enters the post-conviction order at the guilty plea statement as opposed to the sentencing hearing.
Okay.
Because technically, we're no longer pre-trial at this point.
I kind of disagree. I don't think the conviction's final until the J&S is signed, so.
There's I certainly understand both parties today. I'm not going to have it's just it's how this court does it, and that's what I'm going to go ahead and do here today. So I will need a minute to get that no contact order filled out. Because do you have access to OnBase, Mr. Kilfoyle?
I do. It's just going to take me a minute.
Okay. Well, I've got to work on a few other things. If you can work on that, that'd be appreciated.
Absolutely.
Mr. Rister, we're working on it. Give us just a few more minutes, and we'll get you on your way here very shortly, sir. Thank you for being patient.
No problem.
All right. So we have to
Glad I get to pay my bills and keep my apartment.
All right, that's
It
good
was-
news, certainly, Mr. Rister. That is good news. I'll be just one more moment, sir. Okay, so the judgment and sentence, as we did earlier, I'll need signatures on that because it is effectively our continuance. The judgment and sentence just has the guilty finding on it and indicates that sentencing is set to October 24th at 1:30 p.m. Presence in person, I am requiring in-person presence, I think, for sentencing at this point. So you can't zoom in, Mr. Rister. You got to be at the courthouse in person for sentencing tomorrow. And then I indicated in the other box at the bottom of the order there, by agreement of the parties, defendant is PR to appear for out-of-custody sentencing.
I can do it.
No problem, Your Honor.
Mr. Rister, do I have your permission to sign on your behalf for that document?
And Your Honor, my
Yes.
is no longer working.
Yes.
My day for technology.
All right, I'll try and get it in. All right, I think I've got it. So, Mr. Rister, here's what the no contact order says. It completely mirrors the pretrial one, so it isn't really different at all, except now it's post-conviction. Excuse me, what this order says, protects the party by the name of Laurel Rister. It does prohibit you from doing a number of things. Do not cause, attempt, or threaten to cause bodily injury. This includes any type of assault, harass, stalk, or keep under surveillance the protected person. Simply don't have contact with them. It is face-to-face. It's through a third party. Includes electronic and written contact, so texting, phone calls, emails, social media, all prohibited with this protected party, sir. There will be a caveat to that. Do not knowingly enter, remain, or come within 1,000 feet of the protected person's residence, school, workplace, vehicle, or wherever she may be. That order does also indicate, just as the pretrial order did, defendant may have contact with the protected party through the Talking Parents application. Using that application, the parties may communicate about a child in common, shared guardianship only. Defendant may have contact with the protected party to facilitate exchange of child in common through a third party or with a third party present. It's it is a post-conviction order, so it's a 5-year order. It will remain in place until this date, October 23rd, 2029, unless it's modified or rescinded in the meantime. Do you have any questions, Mr. Rister, about the terms of that order?
No, sir.
Okay. Is it acceptable to you if Mr. Gardner signs that order on your behalf, acknowledging that you understand the order and that I reviewed it with you?
Yes, sir.
Okay. Thank you, Mr. Rister. And if you haven't already, Mr. Kilfoyle, can you sign off on the JNS just since it's the continuance? Okay, I think we've covered it. Let me just double check I didn't miss anything here. Okay, I think we're good to go. Mr. Rister, you will be released today on your personal recognizance. We will see you tomorrow afternoon at 1:30, sir. Please, please be there.
Yes, sir.
Thank you. Have a good day, Mr. Rister.
Just a quick pause. Yes, Salty Buddha, this is Tiny Kitten Esquire. And she's feisty right now because she was destroying the little octagon pad or hexagon pad that the buttons are on. She was destroying it. That's why it was going outside, outside, outside. Yeah. She was having fun with it. But it's yeah. Oh yeah, your girl is so jealous of this one. And so is Billy. Yep. And Billy and Esquire, they get in quite the battles over who gets to cuddle with Mama. Don't you dare go and mess with those buttons again. Unless you're going to actually use them, you know?
Okay. Mr. Hooper, was that the last one you were here for?
Was, Your Honor.
Great. All right. Have a good day. Okay. All right. We'll go ahead and call Mr. Let's see here. Where is Zachary Flatt, 4A01738840 and 4A0694837. This is on for review after competency. Good morning, Mr. Flatt.
Morning.
All right, I did get to see this one ahead of time. Would either party like to be heard on the finding?
No, we're not agreeing to the order, so.
Okay. As far as the finding being made, though, you're agreeing that Mr.
Oh, yeah,
Flatt's
well,
not
I
correct.
haven't actually seen the report, but yeah, well, if the court's gonna adopt a finding.
Okay.
Yeah.
Court will find that based on that report from DSHS, Mr. Flatt is not competent to proceed at this time. So, it sounds like the city has a request that is not in agreement by defense, so go ahead with your request first, Mr. Kilpaw.
Your Honor, Ms. McGrain would like to see restoration for these matters. I know the defense counsel doesn't agree, so we're just asking to set this matter over to Friday on the custody. It's Ms. McGrain's calendar. This is her case, so that she can make the argument as for the restoration at that time.
Okay, give me just a minute then, because I'll need to upload. I mean, frankly, maybe the court will just wait till Friday to make the finding then, because O Court only has two options. If the finding is incompetent, order for dismissal with the finding of incompetency, or order for restoration with the finding of incompetency. So,
And the statute, Your Honor, actually says, it says includes this, if there's an agreement to a diversion program. This is 1077-088, which I don't think that we have an appropriate diversion program here, and I'm certain that the prosecution wouldn't agree to it. Then Section 1A says that the court shall dismiss the proceedings without prejudice and detain the defendant pursuant to subsection 6, which is the DCR, unless the prosecutor objects to the dismissal and provides notice of a motion for an order for competency restoration treatment. So the actual paperwork that the statute requires is motion and notice of hearing for the motion. I'm not going to make, that big of a deal out of that, but.
So I guess all I need to know for today's purposes are the parties in agreement to set it to Friday morning to actually have the substantive hearing about the motion for restoration?
Yeah, we're going to waive our objection to the non-compliance with the statutory notice.
So I'm going to retract. I haven't signed off on any order. I'm just not making the finding as to competency today. We'll set it over to Friday morning. City can make their request, the reasoning why they want the restoration.
I'm bringing this up more for future reference.
Sure.
Because I think that for my cases where these issues are present, I'm going to be following the procedure that's laid out in the statutes available to my clients.
Counsel, what subsection was that specifically?
That's subsection 1A, that when, after the order for the finding the defendant not competent, it says that the court shall dismiss it unless the prosecutor objects to the dismissal and provides notice and notice of a motion and a motion for motion to restore competency. So I think that's the paperwork that's contemplated by the statute.
And that's which section of 1077 is that?
That's 1077-088, subsection 1A.
Okay. All right. Well, I'll take a closer look at that, obviously, and we can address for today or for this case's purposes. It sounds like we can address the city's request on Friday. So I'm just going to fill out a motion to continue right now, not making any finding as to competency. So it'll just be a review hearing Friday morning, October 25th at 8:30. Time is still told for the next 2 days. And it sounds like it's essentially city's request to continue. You just want me to write assigned prosecutor to make argument? I mean, what do you want as the basis of the motion?
I think that's fine. Assign prosecutor to make argument for restoration.
Okay. And since defense is only as to the court rule, or essentially the statute, the timing, waiving their objection.
We're going to waive objection to what we view as possible we'll even call it possible non-compliance with the statutory requirement. But I just wanted to make people aware of, of the procedure that the statute contemplates, essentially.
All right. Frankly, it's been a long time since I've looked really closely at it, so I'll take a closer look as well. All right, I'll get out of the motion to continue for Mr. Flatt. It's just a standard continuance. It should be ready for signature.
Yeah.
All right, Mr. Flatt, I'll see you Friday morning, sir. That's October 25th at 8:30.
Thanks, bro.
Thank you. Mr. Gardner, anyone else ready to go?
I would call Pinkley. I'm not seeing that in the report.
Have that on my list. Who is it?
Jonathan Pinkley, 3A0307543.
All right. Good morning, Mr. Pinkley.
Good morning.
Is he actually, like, we have his case and everything? Okay. All right, it's going to be just a moment, Mr. Pinkley. It looks like your case didn't get added to the calendar. My clerk is adding it right now, so it'll be just a moment while he gets it on the calendar. I think realistically we can probably just proceed. I'll fill out the paperwork momentarily. According to the jail roster, it looks like this was a $1,000 bondable bench warrant that was returned on one count of theft third. My only question is it in pretrial status, or do we have to arraign Mr. Pinkley?
I don't know, Your Honor.
So it's an arraignment? Okay. All right. So, sorry, sir. Go ahead.
I never knew I had this charge. I was not aware of it.
All right, and we are going to address that in just a moment. That is certainly something I'm guessing your attorney will bring up here on the record, Mr. Pinkley. Mr. Garner, did you get a chance, or did Mr. Powers get a chance to speak with Mr. Pinkley?
I do not know the answer to that. Mr. Pinkley, did you talk to Mr. Powers about your rights as somebody who's charged with a crime?
Yes.
Did okay.
The
attorney,
the
over in the courtroom there.
Yeah.
Yeah.
Okay.
Do I have the right case number?
All right, there we go. It's 3A0307532, and if you reload or refresh Jabs and Ocourt, it is now on the calendar. So it should be there. Jonathan, it says Pickley. Is it Pickley or Pinkley?
I think that there might be
Pinkley.
Misspelling on the citation. I don't have the file. My office is running it up, but I'm guessing that considering the defendant was picked up on some Superior Court matters as well, and those aren't even showing the system, I think we might have a misspelling of the name.
Okay.
If we could inquire of the defendant the spelling of his name.
It sounds like you said it is Pinkley, sir?
Yes.
Is it Pinkley?
Yes.
Okay. Let's just upload an order on motion. We'll correct that. All right, we'll be a moment again. Thank you for your patience, Mr. Pinkley. We're just trying to get the paperwork in order here. All right, so the order on motion just says amend citation to reflect defendant's proper spelling of last name to Pinkley. Again, Pinkley. I'll go ahead and get out of the order. Is there any objection by either party to that order?
No objection.
All right, I'll just get signatures on the order on motion, and then we'll go through with the arraignment. It looks like this is from March of 23, so a little bit older. And then, let's see here. Okay, so probable cause was established back. It looks like the hearing was actually on April 10th of 23. Judge Lev reviewed it, found PC established. So, are we ready to go through with the arraignment?
Sure.
Okay, Mr. Pinkley, you did indicate you reviewed your rights with the attorney over there. Did they also review the charge with you?
Not really. I don't know what this is.
Here's what I'll do. Let's just go through what the charge is. It's one count of theft in the third degree. That is a gross misdemeanor, Mr. Pinkley, punishable by a maximum penalty up to 364 days in jail, or a $5,000 fine, and a $5,000 fine, technically. That's just the maximum penalty. The charge itself, the allegation is that you took property of another in an amount under $750 with the intent to deprive that party of the property. The date of violation alleged here is March 24th of 2023, and it says Bellis Fair Parkway. I'm going to go ahead and guess, is that Target?
That is Target.
At Target, then back in March of last year. So I don't want you to talk at all about the facts of the case, but do you understand what the charge is, Mr. Pinkley, and what it means?
Yeah.
Okay. As far as your rights, I do just want to confirm them, because I can read through them with you if you wish, but do you feel comfortable with them, having reviewed them with counsel?
Yeah, I'm fine.
Okay. All right. At this time, then, are you comfortable, Mr. Gardner, if I just enter a not guilty plea?
Yeah.
All right. Not guilty plea is entered on your behalf, Mr. Pinkley. That will preserve all of your constitutional rights here in regard to this one charge, and I'll hear from the city on release.
Your Honor, at this time, the city would be asking for $1,000 appearance bond. The defendant's been in warrant status for quite a while in this case. I do understand that he states that he didn't have any notice of the hearing. However, it has been quite a while that this warrant has been sitting out there. I can also tell the court the defendant's currently being held on a robbery in the second degree on a $2,500 appearance bond. I do believe that this is an appropriate recommendation for this type of charge. I don't have his actual criminal history pulled up yet because in Jebs it's still just Pinkley, not Pinkley. So I'm not sure what other history he might potentially have at this time.
My clerk does have it pulled up. It's not extensive, so I'm just going to read it. There's 2 D3s out of Ferndale from 2021 showing guilty convictions and warrants having been issued on those cases. Not active, obviously, at this point. It looks like an A4 and theft third out of Whatcom Superior Court from March of 22 showing guilty convictions, but no warrants were issued on that case. And then we have the pending A4 Rob 2 out of Whatcom Superior Court right now. It did have an active warrant. It's still technically showing as active, but he's been booked on it, so I'm sure it's going to be served. And that's everything. That's his entire history with his correct name. So, did defense wish to be heard?
Yeah, we do. The docket notes indicate that this was not initially charged by citation, that there was a criminal complaint. Specifically states the citation was not served on the defendant. The citation and notice to be mailed by the court. That mail returned undeliverable. And so it does appear that Mr. Pinkley is, that his story that he just was completely unaware, the fact that this was a criminal charge is backed up by the information that we have here. So I would ask that the court PR him on that basis.
Well, especially since they didn't even have the correct spelling of his name. So I'm quite certain that he's telling the truth, that he had no idea of the charge.
Mr. Pinkley, sir, you are held out of Superior Court. Are you going to be able to post that bail, sir?
No.
Okay, so here's my question. I would be willing to PR you on this, but if you want to receive credit on this while you're held out of Superior Court, I'll enter a low bail amount. Do you want to get credit, or do you want me to PR you?
I would like to be PR'd. I would like to put a few things in order before I come back.
Well, you're not going to be released on this unless you can bail out on the other one, Mr. Pinkley.
Is there any way I could be PR'd on both?
So we don't have that other case before us. We're not that court. That's the Superior Court case. So what if we impose a bail of $50 on this?
I don't have any funds. I have nobody I can call. I have no family here.
So, Mr. Pinkley, maybe I didn't explain this well, and I'm going to try and clarify it for you. There's two different cases. This is Bellingham Municipal. This is the one count of theft that we just discussed. You are also being held right now on a $2,500 bond or $250 cash out of Superior Court. Sounds like you cannot post that bail. So what I'm telling you is I would be agreeable to PR you on the Bellingham case, on the theft. But regardless of what I do on this case, you're still going to be held on the felony. So if you want me to impose a low bail on the theft so that you get credit while you're also held on the felony anyways, I'm willing to do that. Does that make sense?
Sure.
Okay. I just want to make sure we're on the same page.
I think so, yeah. So you'll get credit for this and that case, and they'll have to divide that up maybe at some point. But
All right, that's $50. It's essentially a $500 bond, $50 cash, whichever Mr. Pinkley wants to post is fine with me. I'll give both options. And that is based on the court will make a finding, although he did not get credit or notice here based on the docket history. He does have other cases with warrant history, so I think the court can make the finding reasonably that there is some risk of flight. I'm going to find you eligible for the public defender, Mr. Pinkley. I will get you an attorney on board. Other conditions here, sir, very straightforward. Simply appear timely for court, have no new criminal law violations while the case is pending. Do you have any questions, sir, about any of that?
No.
All right, we're going to set 2 court dates. One is in custody, one is out. The in custody date, I guess it is one of your cases, Mr. Kilfo, so you find just the standard 2 weeks?
Yeah, 2 weeks is fine.
All right, Wednesday, November 6th at 8:30, and the out of custody is 12:10 still good? December 10th at 1:30 in the afternoon. If you post the $50 here and the $250 out of Superior Court. Okay, Mr. Pinkley, I think I've covered everything, sir. Is it agreeable to you if Mr. Gardner signs the pretrial order on your behalf, sir?
Yes.
Okay, thank you, Mr. Pinkley. You're good to go, sir.
Thank you.
Huh, you know what? Yeah, we need to backtrack for just 1 second. I think I only addressed the arraignment. Miss Oldham technically had a pretrial on today. Did we just want to track that pretrial along?
Yeah, why don't we just set that for the next court date on this?
Yeah, I'll throw up a motion to continue here, and we'll set that over to November 6th as well.
No, this was the date.
This was it. Okay. So I think we're actually running from today on that, if I'm not mistaken. Is that correct, Mr. Kilfoyle?
That is correct.
Okay, so we can do 2 weeks without any sort of waiver at this point.
Essentially, yes.
Okay. Are you fine with just doing the 2 weeks?
Yeah.
Then?
That's
Okay.
fine, Your Honor.
All right, I'll go ahead and just fill out a motion to continue for Oldham on that one. I will, of course, need signatures on it in just a moment, but I'll fill it out here. All right, I'm signing off there as well. Okay, I think we're back on track. Anything else ready to go, counsel?
Oh my goodness, Billy is refusing to share the window. It is chaos. I've had things flying off. Hey! Stop it! The last person you attack is Earl. He's the sweetest one of all of them. My goodness. Told you it was chaos. Yeah, I just sitting here, all of a sudden this canister comes flying off of that shelf, which was Earl, he jumped because he was startled because Tiny Kitten Esquire came flying through under the desk over here, and he wanted to get in the window, but Billy is taking up the entire ledge, very much on purpose. And so Esquire sat here on this box, and Billy just wasn't having it. So yeah. Oh yes. All day, every day. Yes. They have they get along for short, brief moments, but they're few and far between. So I well, I saw both of them, but I saw Esquire's paws doing a little more of that. Oh, and Earl's not a fighter. He is not a fighter, not at all. They're growling. I need to go deal with this. So, thanks for coming out and hanging out with me. This was fun. I love you all so much. Be safe, be well, sleep sweet, and much love.